In Spokane County, we have a very unique guardianship program. And one of the things that's so unique about it is not only how long we've been doing it, but how committed the people are that work for that program, some of which are here today. And the reason that I mention that is because it's one of the things that strikes me about guardianships in general, but also about all of the people that we see here today, each and every one of us, is our commitment to not only the issue, but most importantly, probably commitment to the people that are subject to guardianships and subject to, unfortunately, some of the things that happen to us in our lives as we get older. One of the things that also strikes me is the name WINGS. When we talk about WINGS, if you pronounce it all out, it's a very, it doesn't really flow very easily, which I'm sure is why we have the acronym WINGS. But the last portion of that is stakeholder. And one of the things that I have constantly thought about is why we emphasize the word stakeholders. And I think in this particular case, one of the reasons why is because each and every one of us, not just in this room, but each and every one of us that hopes to live a long and fruitful life is a stakeholder with regard to guardianships. The reason for that, and I think it's important to think about this, many of the other areas that we're asked to focus on require us to rely on our own sense of social responsibility or our own sense of ethics to help someone else. And while that is admirable, it's a great thing, guardianships, and in fact, if we do to live to be a ripe old age, very, very well will affect each and every person that's in this room. It's not like poverty that may afflict some of us or may not. It's not like drug addiction that may or may not. If we all live to a ripe old age, it very likely will be one of you that will be affected by this, or all of us that will somehow be touched by this, which makes every one of us a stakeholder. I was talking with Tina Baldwin and Tom Coleman this morning. Tom Coleman's here from California, and he's involved in a lot of different things down there. Both of them are. And one of the things that he mentioned was that as he works through some of these issues, that he finds that many of the court systems, many of the other systems that are in place, these are new issues for them. And one of the things that I thought about is I thought, it seems strange that these issues are new since the last time I checked, people have been getting old for a long time. I mean, it's something that has happened over and over, and yet many of these things are new, which is one of the things that's important and that really emphasizes the importance for these sorts of get-togethers. What WINGS really hopes to do is to establish patterns, principles, practices that can be used to better serve the people that come into contact with guardianships, which again is every one of us. While some of these issues may be new to some people, they certainly aren't new to everyone. And it's those people who have contacts, those people who have experience, who we hope will come forward and share those things with those of us who can certainly learn a little bit more about what we're going to do moving forward. I'm also very fortunate to be able to introduce Bob Fleischner. I asked him before this whether or not he should be introduced as Robert or Bob, and he very quickly pointed out that it should be Bob, and what I took from that was that he has a certain amount of humility, which I think is remarkable considering the things that he's accomplished. He is working out of Massachusetts. He is responsible for the authorship of some of the most significant books on guardianship in Massachusetts. He is a coordinator for the Center for Public Representation, specifically the coordinator for their supportive decision-making, which is what he'll be speaking about today. He's written numerous pieces for law journals and other articles about guardianship and disability law issues, along with many other areas. He's been practicing for a long time. He has not only a remarkable breadth of knowledge, but he also shares not just an interest, but a commitment and a passion for guardianship and disability issues, which is not only necessary but is also very admirable. Probably the most important thing, again, is that he not only shares the interest for the subject matter, but he also shares an interest and a passion for the people who are subjected to those. Without further ado, I would like to introduce Bob Fleischer.
Well, good morning. As the Commissioner said, I'm Bob Fleischer. I work at the Center for Public Representation, which is a public interest law firm in Massachusetts. And we're a national law firm. We have been representing people with disabilities for over 4 decades. Most of our work is on behalf of people who are segregated in institutions, mental hospitals, IDD institutions, nursing homes, prisons, jails, or in segregated day programs like shelter workshops, day hat programs, and so on. For all the time that I've been practicing, my practice started really in the juvenile court, primarily representing families and children in what we call care and protection cases, which are child abuse cases. And it became clear within about the first day that nearly everyone involved in the cases that I was appointed to represent someone had some sort of a disability, either a mental health disability or an intellectual disability, and that was having a real impact on their ability to work their way through very difficult family issues and work their way through the court system. That led to an interest in guardianship, and I've done a lot of work representing appointed guardian, representing respondents in guardianship cases, what we now call alleged incapacitated persons, which is kind of a terrible phrase. Representing a lot of that, and I've been involved, worked as a guardian ad litem, and been involved in guardianship reform in Massachusetts. And one of the things that I came to learn in a process that took us 15 years, Massachusetts has a very robust case law. Our Supreme Judicial Court, which is proud to say that it's the longest continuously serving appellate court in the Western Hemisphere, and sometimes behaves like that. But our state Supreme Judicial Court has written probably more opinions than almost any other state in the country about guardianship, and most of our guardianship law had been created through case law, through common law, particularly in the areas of guardian's authority. But our statutory law, much of what was written during the Puritan era, in the 1600s, some of our law actually carried over from prior to the United States Constitution. And our statutory law fell far behind the rest of the country and far behind our case law. So about 20 years ago, the state probate court in Massachusetts, this probate court that handles guardianship, trusts, and estates, began an effort with the 2 major bar associations to amend the guardianship law and the trust and estate law in Massachusetts using the Uniform Probate Code as a model. And it took 15 years, although there was absolutely no opposition to Article 5, which is the part of the probate code that deals with guardianship and is the equivalent of the Uniform Guardianship and Protected Persons Act. It took 15 years to get it passed, totally changed our guardianship processes, and the probate court was given 6 months to implement it, which was a massive undertaking. So within 6 months, the court, with a really spectacular chief judge and an implementation committee, in which I was a member of, got the guardianship process in Massachusetts changed. And that was an important moment for advocates for guardianship reform and advocates for fairness in the guardianship process and advocates for guardians and advocates for petitioners' counsel and defendants' counsel. But it and it was something that I was proud to play some small part in. But the more that I thought about even the changes and the reforms in Massachusetts, in the context of the rest of the work that I do, I began to question guardianship at its foundation. And as I said, most of the work that we do is on behalf of people with disabilities, and it's founded in concepts of independence and integration. That people should be able to make their own decisions about their lives in settings that are integrated into the community, in which they have contact not just with paid staff people in segregated settings, but actual integration into the community. And in many ways, guardianship, at least at its worst, is antithetical to those ideas. So we began to think and explore alternatives to guardianship. And we've always had the familiar alternatives to guardianship, like durable powers of attorney, what we call healthcare proxies, which are advanced directives for healthcare, trusts, and other kinds of arrangements. And as we looked into it, we became aware of supported decision-making as a movement in the world and began to think about what we could do with that. So what I'm going to try to describe to you today is a couple of things. Some background on some things that I think you probably already know about the different life experiences of people with guardianships as compared to people who do not have guardians. And even the difference between people with limited guardians and people without guardians. I'm going to try to describe to you some of the principles of supported decision-making, some of which you may be very familiar with or have heard something about, and then describe to you in particular, since what Shirley asked me to talk about was the actual implementation of a supported decision-making project, a pilot project which we initiated in the western part of Massachusetts, and which we have now completed for our first phase, which is about 2 years, 2 years of work, and we're going to move into the next phase, and I'll tell you some of the things that we have learned, some of the barriers we faced, some of the barriers which we haven't overcome, some of the concepts about which we're not entirely sure, and some of the questions that come to our mind. But try to tell you that, or to leave you with the impression, I hope, that supported decision-making really is a firm, workable, constructive alternative to guardianship, and talk a little bit about the world movement for supported decision-making. And at least in many places in the world, and perhaps in the United States, it may be the future of guardianship. Now, some of the information that I'm going to relate to you comes from what's called the National Core Indicators. One of our partners, and I'll describe their role to you in a little while, in our pilot project is an outfit called HSRI, which stands for Human Services Research Institute. HSRI is in Cambridge, Massachusetts. I think they also have an office on the West Coast. And they do research about human services, particularly about people with intellectual disabilities, developmental disabilities, and mental illness. And they collect something they call the National Core Indicators from 42 states and the District of Columbia. And these are information about people with intellectual and developmental disabilities and how their service systems and what their lives are like in the 42 states. A small part of the National Core Indicators has to do with questions about guardianship. And HSRI and the National Core Indicators Project has learned a few things about guardianship, which probably will not surprise you, but which do quantify some of the things that many people believe. So, for example, they have found, the National Core Indicators have found that there is a fairly substantial difference in the way that people under guardianship or limited guardianship, either full guardianship or limited guardianship or no guardianship, have input into choices that they make about their home, where they live, their roommates, their staff, their daily schedule, and what to buy. And what this indicates, probably not surprisingly, is if you don't have a guardian, you're more likely to be making your own choices. It also indicates that many people under guardianship do have a say in what they do, because that's the way their guardians operate. Even though they are substitute decision makers, the substituted decision maker includes the person for whom they are caring in the decision making. Although the ultimate decision is, at least under full guardianship, is with the substituted decision maker. Same thing's true on relationships. Probably won't surprise you that the biggest difference is in dating. And this slide, which is a little confusing, probably confusing to you, and it's confusing to me, but the import of this table is that the differences the variables that you saw in the previous two slides don't matter based on the degree of disability. So that people with limited, with what used to be called perhaps mild mental retardation or mild intellectual disability, may have the same degree of lack of decision making as people with much more profound disabilities. The far side of this slide, to me, is the most interesting of the data that the NCI has collected. And that is that 50%, nearly 50% of the people with intellectual and developmental disabilities in the 42 states that are measured, so we can probably expand that to the United States, who receive services from the state are under guardianship. 1 in 2 people with a developmental disability who are receiving state services in the United States has either a limited or a full guardian. That's a lot of people. That's a lot of guardianship. And that has implications for the people, it has implications for the system, it has implications for the courts, it has implications for those of you who serve as guardians, and there are those of us who think that's probably too many people. So, this is a quick review of some of the reforms that have gone on in the country. They've gone on here, they've gone on all over the United States. And many of these things, as you're going to hear at lunch from Philip, were promoted by articles by the Associated Press several decades ago about guardianship abuses. And states responded to that by changing some of their guardianship laws in ways that were intended to protect the person who's potentially under guardianship. These include things that nowadays seem very routine and sensible to us. The person who's going to be under guardianship has a right to know it. Notice. That didn't used to be true. A very profound change, at least this has been a remarkable change in Massachusetts since our new statute went into effect in 2011, is that the person has a right to be present in court. That was almost never true before. Almost never did a person was a judge able to actually see the person who was being placed under guardianship. Periodic review. Guardianships in Massachusetts, at least, and in many states in the United States, are forever, or were forever. And we're not subject to periodic review, or to reporting, or to court oversight. Well, there were provisions for filing of reports, but guardians could go decades without filing reports, and no one would know, because there was no system for knowing whether those reports have been filed. Higher expectations of proof. Most states have not changed the standard of proof, so you don't have to prove guardianship beyond a reasonable doubt, or even by clear and convincing evidence in most places. But it's still a civil law standard of proof, preponderance of the evidence in most states. But there's higher expectations of proof now than there ever were before. Medical certificates. So I read the Washington statute. The guardian ad litem is required to bring in proof from a doctor or other medical professional about the need for guardianship. In Massachusetts, that form prior to the reforms was a one-page form with 3 check boxes on it. And the doctor would sometimes check all 3. Yes, the person needs a guardian. No, the person does not need a guardian. Yes, the person needs a limited guardian. You would see those all the time. And then it would say, what do you base this on? And the doctor would write in, person is incompetent. And that would be enough. But you can't do that anymore, and you can't do that in most places, and that's a good thing. So all of those things have happened. The movement for limited guardianships. Probably every state now has a preference, statutory or case law preference, that if a person's going to be under guardianship, the guardianship should be limited to just what it is that the person needs help with or can't take care of on their own. So this is a recognition that a person may be incapable for one reason, but not for another. So virtually every state has a requirement that courts consider limited guardianships. In Massachusetts, our rule is that you start with limited guardianship. The judge is supposed to look at that first. We had a case in Massachusetts in the mid-1970s, a young man named Larry Bassett. Larry was living at what was then an MR institution. And the court in that case, the judge in that case, said he doesn't need a guardian for every purpose, and ordered the guardian and the guardian's counsel to come in with a plan to limit the guardianship. It took 10 years for that to happen. It was 10 years before Larry Bassett's guardianship was limited. The American Bar Association collects data on limited guardianship, and their conclusion is, and I don't think this will be a surprise, that limited guardianship is honored more in the breach than in the implementation. That no matter how strong a state's rule is on limited guardianship, most guardianships are plenary guardianships, or nearly plenary or full guardianships. Right to counsel has been a big change. Not every state has the right to counsel in guardianship cases. Some states have right to counsel in every guardianship. Other states have conditional right to counsel. If you ask, you get one. Or if somebody asks, you get one. Or if the commissioner or the judge feels that the person should have counsel, then one is appointed if the person's indigent. That begs the question of what's the quality of the representation provided by the counsel, and what does the counsel see as his or her role? We looked at the Washington statute, and it seems pretty clear that the counsel's role here is as an advocate, and that's what it ought to be. The guardian ad litem's job is to think about best interest. The lawyer's job is to be an advocate. And that's the best rule. But that's not the way that it happens in every state. Those are all procedural reforms, and they're important. Then there were substantive reforms. And these very, very important substantive reforms that went primarily or most importantly, in my view, to the definition of competency or capacity. Prior to guardianship reform and prior to the Uniform Acts, in many states, you had a guardianship fit into a category. So if you were mentally retarded, as the word was used then, or mentally ill, or elderly, which is, the commissioner points out, is going to be all of us, some of us already, and all of us eventually. If you were a spendthrift, that was one of my favorites. Kind of an odd word for someone who spends all their money, but that was a standard. If you're a spendthrift in Massachusetts, you got a guardian. Those, also scary. Like, as we are all going to get old, we probably all spend our money, what little we have, not very thoughtfully. Those are all, categorical guardianships are gone almost everywhere and replaced by a functional test of competency. Now, the one that or capacity, and I'm using the words competency and capacity interchangeably. The one that is the most common now is the one in the uniform laws. And it is a functional test that looks at, can a person take in information? Can they evaluate the information? And can they make or communicate a decision? And you keep this in mind because we're going to come back to this when we talk about supported decision making, because it works on a different concept. Capacity is a different concept under supported decision making. So that the person is able to do that or unable to do it, that they either have the ability or don't have the ability to make decisions about physical health, safety, or self-care. The Washington statute, at least as I read it, is a little bit different because it defines, as I read it, capacity as having to do with risk. bear a significant risk of personal harm based on a demonstrated inability to adequately provide for these various needs. It's a different wording, but it's the same concept, I think. It's really a functional concept that isn't categorical, and that's what's important. The current statutes, many of them recognize the importance of assisted technology and recognize, as I mentioned, that guardianship or capacity can be on a continuum, that I may be able to make decisions about how to spend $1 million, but I can't figure out how to spend 5 responsibly, or the other way around. So all of that leads to supported decision-making. And supported decision-making is I don't know what to call it. I guess, for lack of a better word, let's call it a movement, because I really think it has characteristics of a movement. Supported decision-making was not invented by, but has been spurred on by the Convention on the Rights of Persons with Disabilities. That's a UN treaty that, as I'll describe in a minute, has been ratified in the majority of the world. So the CRPD, as it's known, and advances particularly in Canada and Europe about supported decision-making have led it to be seen in many places as an alternative to substantive decision-making, to guardianship, or to representative payees, or to any of the supported decision-making methods. So here's something, this colorful chart is about the convention. It was ratified 10 years ago this year, or it was adopted 10 years ago this year by the UN General Assembly, entered into legal force, which means it became an enforceable treaty, whatever that means, in 2008. And as of last month, 162 nations in the EU had ratified the CRPD, some with reservations. The United States signed the treaty in 2009, but it has not ratified the treaty. So we are not a state party to the treaty, but we are a signer. I think there's been one vote in the Senate, and as you know, it takes, 2/3, I think, under the Constitution to ratify a treaty. The Senator Bob Dole made his only appearance on the floor of the Senate since his presidential campaign to urge adoption of the CRPD, and it failed. So this map just illustrates parts of the world that have adopted the CRPD. The important part of the CRPD for supported decision-making is Article 12. And Article 12 may be the article from people I've talked to who played a part in the drafting and adoption of the CRPD. This may be the article that was subject to the most debate, and at least in my opinion, is from the reading that I've done on it, is in many ways the most ambiguous or the most subject to interpretations. People interpret Article 12 quite differently. But even on the more conservative end of interpretation, it's pretty clear that it has a lot to say about capacity, competency, and guardianship. And it has 3 major parts, Article 12, that have a relationship to supported decision-making. The states parties, those are the countries that have ratified the treaty. They reaffirm that persons with disabilities have the right to recognition everywhere as persons before the law. So that seems fairly straightforward. People with disabilities are no different before the law than anybody else, any person without a disability. Secondly, the state parties recognize that persons with disability enjoy legal capacity on an equal basis with others in all aspects of their lives. And this is the place, and these are the words that make the CRPD potentially different than the way that we look at capacity in this country. And I'll talk about that in a little more detail in a minute. Third, the state parties agree to take appropriate measures to provide access to persons with disabilities, to the support that they may require, there's the supportive decision-making element here, to exercise legal capacity. So the state parties agree to do what's necessary to support people to exercise their legal capacity. Now, it's worth saying that countries that sign and ratify the CRPD take it seriously. We, in the United States, we often tend to be quite dismissive of the United Nations treaties, even those that we have ratified. The Treaty Against Torture, or the Treaty on Declaration of Human Rights and things. It's international law, it's trying to create one world, and it invades our sovereignty, and you hear those arguments about UN treaties often. But in other parts of the world, countries take the UN treaties very seriously. Not to say that we don't, but at least with the sometimes. But with the CRPD, countries are actively working to change their laws to conform to Article 12 of the UN Treaty. So there are nations around the world that are making serious and indeed profound amendments to their guardianship law. Some countries are considering abandoning guardianship. It's taking it right out of their statutes. Ireland has considered that. Sweden has. As far as I know, nobody's done it, but it's on the table in some countries. Countries are looking very actively at alternatives to guardianship, and particularly supported decision-making is one of those. So the states' parties have to appear every few years before something here's the stuff that scares people about the United States, something that's known as the committee. And they have to explain to the committee what they've been doing to conform their laws and practices to the treaty. And the nations go and do that. And they're usually accompanied by dozens of NGOs, nonprofits, from those countries who go to tell the committee that the nation is not doing what they said they're doing, or they're not doing enough. And this is a serious process that people take seriously. And so we are beginning to see around the world changes to the way that guardianship is administered and thought about. In Sweden, for example, there's now something called I'm sure I get the pronunciation of this wrong. I think it's the Godman. It's spelled Godman with a small g at the beginning. And it's almost like an almsbuds person. And the Godman's job is to act sort of like a guardian acts, but they can't make any decisions for the person. In Canada, several of the provinces in Canada are moving toward supported decision-making agreements, and I'll talk some more about that in a minute. So that's Article 12, and that's briefly what's happening in the world. Here's the principles of supported decision-making, what I think it's about. It starts with the idea that people have capacity. Everybody. At least they have legal capacity. Everyone has, under the theories of supported decision-making, everyone has will and preference. Everybody. Will and preferences. Now, when we get into the question and answer period, someone's going to ask, what does that mean? And I'm not quite sure what it means. What it means is that inherently, in every person, there is a will to do something and preferences about things, even if they can't be expressed, and regardless of the extent of the person's disability. And this is the key to supported decision-making, will and preferences can be expressed in some way by the person or understood, sometimes interpreted, by others who know the person well and who are in a voluntary, trusting, and committed relationship with that person. So that's the idea, that everybody, regardless of the extent of their disability, has will and preferences. That means that's what legal capacity is. and that those can be expressed or understood by people who are in a voluntary relationship with them. So, this is how it works. An individual with an impairment, disability, is provided supports that are necessary to make decisions. They are surrounded by trusted individuals, might be family members, might be friends, could be professionals, who are chosen by the individual, and we call them supporters. And the supporters commit to working with and assisting the person to make their own decisions. So they don't say they're going to make the decisions for them, just the opposite. They're going to provide them with whatever support is necessary to help them make that decision on their own, even if it can't be expressed, but can be interpreted. This is the way that Bob Dinerstein, Bob's a professor at Washington School of Law at American University in Washington. This is his definition of supported decision-making, and it's as good as anything that I've seen. So he defines it as a series of relationships, practices, arrangements, and agreements of more or less formality and intensity designed to assist an individual with a disability to make and communicate to others decisions about the person's life. So you can see that this is a pretty broad definition and could include lots of different forms of supported decision-making arrangements. And that, I think, is intentional. And the pilot projects that are going on around the world, although they share commonalities, in many ways are quite different one from the other. So what about legal capacity? I mentioned this several times, and it's a key. Legal capacity and mental capacity, which is what we really think about when we think about guardianship, are not the same thing. Legal capacity, as I said, recognizes will and preference, and that they are the core of decision-making. And it focuses on supports and accommodations that will enable someone to enable will and preferences to be known and to guide and make decisions. So how's it implemented? As I said, there's no single model. Most supported decision-making pilot projects around the world draw on existing social constructs. If you've worked with people with developmental disabilities or intellectual disabilities, you may be familiar with something called circle of friends. Friends and cohorts of individuals with disabilities get together and help and provide support to the person. Or person-centered planning, which is the basis of most individual planning for people with intellectual disabilities in the United States. Those existing constructs, plus existing support systems, can be used and drawn on to create a supported decision-making system for an individual. It can be informal or formal. As I'll describe to you, we've chosen to make it semi-formal, and I'll tell you how we did that when I get to our project. So it can be formal in the sense that it can be authorized by law, it can be on a pre-prescribed form. In some cases, in some places, it requires court sanctioning. May not be court sanctioned. There may be a registry where supported decision-making agreements are filed that provide it with some sort of authority. It can have support and authority in statute, and there are some statutes. British Columbia, your neighbor, is probably the leading example and the first, I think, first jurisdiction that I'm aware of to pass a comprehensive supported decision-making statute. British Columbia statute is quite complex. It's a couple of pages. It has a process. It has a prescribed form that you have to use. It has certain language that you have to use, and it's not entirely without shortcomings. But it is there, and it means that a supported decision-making agreement piece of paper is recognized throughout British Columbia. We have one jurisdiction in the United States as of June that recognizes supported decision-making by statute, and that's Texas. And Texas, just its last legislative session, passed very comprehensive guardianship reform, including a Bill of Rights for people under guardianship. And as part of its statute, it recognizes supported decision-making. Texas is the first state to do so. The Texas legislature said that the purpose was to enable adults to make their own life decisions, including where they want to live, support, services, medical care, so on, who to live with, where to work, without impeding self-determination. So the Texas statute requires that before a judge can order a guardianship in Texas now, the judge must ensure that the parties have explored alternatives to guardianship, including supported decision-making, before a guardianship is issued, before a guardian is appointed. The other key to a very important part of the Texas statute is that the Texas statute, which unlike the British Columbia statute, is pretty short and very straightforward. The Texas statute provides a safe harbor, provides immunity for third parties who rely on a supported decision-making agreement. So if I have a supported decision-making agreement and Shirley is one of my supporters and I don't have a guardian and I go to a doctor and the doctor discusses with me that I need an operation and I say, I agree to that operation after getting support from Shirley on making that decision, and I have a supported decision-making agreement, the doctor can rely on that, even if the doctor thinks I'm not competent to make the decision. And the doctor will be protected from a lawsuit for failure to get informed consent. That's a critical aspect and part of the Texas statute. So, one thing that's really important in all supported decision-making systems is to have safeguards. If the system does not include, one of the objections to supported decision-making that one often hears, and sometimes from judges, is, oh, but there'll be no oversight. What's the protection against the supporters influencing or taking advantage of or stealing the money of the individual who has executed the supported decision-making agreement? And there isn't the court protection. Of course, on the other side, that court protection often is not there. It's there, but getting that protection is often difficult. Courts may not be aware of what's going on. But it is a risk with supported decision-making because you don't have the court as a backup. So you have to build into the system has to include safeguards. There's to be monitoring or oversight of some sort, and I'll describe to you how we try to do that in our project in a minute. Even though there's only one statute in the United States, there are 3 or 4 court decisions that talk about supported decision-making as an alternative to guardianship. Probably the most famous is the Jenny Hatch case, Ross versus Hatch. I don't think this is a published opinion in any way. But Jenny Hatch was a young woman with an intellectual disability who had lived independently with some friends without disabilities. And she was in a bicycle accident in which she got a head injury, I think. And she wound up in a nursing home for rehabilitation. And her family became concerned about her, thinking that she couldn't take care of herself in the community, and got a guardianship, and kept her against her will in the nursing home. She was able to get counsel from the Quality Trust in Washington, D.C. She lived in Virginia, and went to court to try to get rid of the guardianship. And the judge, after considerable amount of time and lots of trials and lots of evidence and so on, limited the guardianship to 1 year and then said that she would be free of, Jenny Hatch would be free of guardianship because she had around her supporters who could help her make decisions. That even if she wasn't fully competent to make those decisions herself, she had enough people to help her make those decisions. In a decision that is reported, it's written by former surrogate judge Chris Glenn of the Surrogates Court in New York, is a case called Damaris L. Damaris L. was a woman also with intellectual disability who was pregnant, and her family was concerned about the pregnancy and moved for guardianship. And Judge Glenn denied the guardianship because she said that Damaris had around her enough people to help her make decisions, including her husband, or the father of a child, I can't remember if they're married or not, and that therefore guardianship was not necessary because she had support. What's interesting about Surrogate Judge Glenn's opinion is that she relies very heavily and gives what she called persuasive weight to the Convention on the Rights of People with Disabilities. Supported decision-making is happening in many other places around the globe, too. We're in communication with projects in Israel. There's an excellent project in Israel. There are several in Ireland, Bulgaria, places where you wouldn't expect this stuff. Bulgaria, Colombia, Chile, other countries are starting to use supported decision-making and looking to change their statutes. So let's get to our pilot. As I said, we were thinking about guardianship and thinking about whether, for many of the people who we represented in our litigation and our class actions, whether guardianship made sense for them. And we entered into a partnership with an organization called Nonotuck Resource Associates. And Nonotuck is a shared living provider. Shared living, if you're not familiar with it, is under Medicaid. It's called Adult Family Care, AFC. Some people call it adult foster care. It's really a model where people with disabilities live with families, with typical families. And the relationships that are built up in supported housing can be quite profound. Some of the individuals who we've worked with in our project have been in shared living situations with the same family for decades. And they've become part of the family. And it's really a very integrated model. It also had, for our pilot project, a real advantage because it meant that the people, we were going to try to select our participants from among people who were getting services from Nonotuck. And all those people came to us with supporters. So that made the implementation of our pilot easier. It also makes it a little unrealistic for a lot of people, for many people who don't have that kind of built-in support. But it did give us a way to start. We were among the first of the pilot projects in the United States. The way it works is that with Nonotuck, we identified about 20 people who were receiving housing through Nonotuck, who seemed to be good candidates for supported decision-making. And we tried, and we were actually successful, in finding a range of individuals for the project. The way it is designed is that the individual who's selected will then select supporters. We have a series of meetings with the individual, and then where we identify places where they can tell us they need help in making decisions. Then we identify with them people who they would like to have them help them make decisions in those areas. Then we have meetings with the supporters and with the individual, and then they sign a supported decision-making agreement, which I'll describe to you in a little more detail in a minute. My office provides legal representation to the individuals if it's necessary to go to court to get rid of a guardian. We work hand in hand with Nonotuck throughout the whole process. Non-attack care managers, their staff, act as liaisons between the individual, the network of supporters, and the community. And the non-attack care managers are also the safeguard. They are the people who are keeping, I don't mean this in a negative way, who are keeping an eye on, is it working? Are the supporters doing the right thing? Are the supporters really supporters? Are they not slipping into a substantive decision-making kind of a relationship? So the non-attack care managers are very important in that way. We had held a planning meeting before we started this because we had no idea what we were going to do or how to do it. And we brought in people who were doing it in other parts of the world, and they told us a couple of things which we implemented. One was have an advisory council, and the other was have independent evaluation, and we've done both of those. So here are two of our advisory council members. This is Paige and Jonathan. It says there's a video, but there isn't. Jonathan is a participant. He has a supported decision-making agreement. Paige does not, but they're on our advisory council. We have people using state services, about what you'd expect. We have some legal scholars, former judges, attorneys, medical professionals, a banker, and directors of human services agencies and family members. The advisory council has been really critical to us because, to be honest, we had no idea what we're doing. And it really helps to have other people who have no idea what they're doing either talk to each other and try to figure out what to do. Out of the 20 people who we initially selected as candidates, we found 12 or 13 who were interested in participating. Not everybody had an interest. Some of their families were opposed to it. Others just couldn't make a decision or didn't follow up. But we identified 12. One of them has since died. But we currently have 8 of the individuals have signed supported decision-making agreements. Although we were drawing from a limited pool of people who were in this supported shared living arrangement, we tried to get a range of individuals, and we did a pretty good job of that. So the youngest of our participants is 24, and the oldest is 79. 2 of the people who we're working with are showing early signs of Alzheimer's, including the woman who's 79 years old. So they have different disabilities and varying levels of support. For example, for the woman who's 79, she entered Belchertown State School, which was one of our MR institutions, when she was 9 years old, and she spent 40 years there. She's been out for 30 years living in the community. Since she got out, she has had many of the same friends. There are people who have stood by her and with her for 30 years with whom she has regular contact, even some who've moved way out of state who come back to visit her. So although she has no family and no familial supports, she has people who have helped her all of her life and stood by her and stood with her as she's made important decisions in her life about how to live her life and where to live, despite 40 years of pretty wretched institutionalization. Those people are her supporters. She selected them as the people with whom she wanted, who she wanted to support her in her decision making. 2 of our participants came into it with guardians. One of them, and I'll describe this in more detail in a minute, for one of them, we discharged the guardianship based on a supported decision-making agreement. For the other, the guardian and the individual both want to get out from the guardianship, but they're a little nervous about it. So we've agreed that she signed a supported decision-making agreement. The guardian has agreed and is anxious to work in supported decision-making, although keeping the guardianship. Many of you here who are guardians probably do all of this anyway. And this is the way that they had worked with, the guardian is their siblings. This is the way they had worked with their sister. And they would like to not be her guardian anymore. They'd like her to have her own life and make her own decisions, but they're a little nervous about it. So we're testing. the supported decision-making system for 6 months. The individuals who are involved have chosen supporters that from across the range. One of them has 2. Another one has 10. And the one who has 10 has got her grandparents, her parents, and her siblings. So as long as she's alive, she's going to have supporters. She's got 3 generations of supporters, incredibly rich, deeply committed family to her, and deeply committed to her making her own decisions and providing support for them. Aunts, past and current providers. This is an issue. We'll talk about issues toward the end, but we have struggled with what if our participant says, I want my non-attack case manager, care manager, to be my supporter. I see her often, I trust her, I like her, we travel together, we do stuff. But she's a paid staff person. And is it right for a paid staff person who may have conflicting interests and conflicts as responsibilities both to the individual and to the provider and to the participant, is it right for them to be part of this support team? And we ultimately decided we're creating a project that says this person should make their own choices. And if that's who they choose, then that's who they choose. And our concerns about that should not control that. And in fact, we have to be very careful ourselves not to manipulate this process. And so we've done that. The project in Israel does not allow family members to be supporters. I don't understand that, and I'm anxious to be in a meeting with them in a couple weeks. I'm anxious to know what their thinking is about that. So at any rate, what we do is we get people together after we've done all of this preparatory work, and then we have documents. We have created something we call a supported decision-making agreement. It's in simple language. I think I included it in the materials that I sent to Shirley. If not, it's on our website. And the person signs it. And the supporters sign it. And we decided that we would have it notarized. And we asked the notary to use a seal, which notaries in Massachusetts almost never use anymore. They use rubber stamps. The notarization of it is, to me, is totally superfluous and has no meaning. But it does give the document an air of officialness. It kind of looks like it might mean something. And since we don't have a statute that says it means anything, you might as well have something that looks like it means something. So we have them notarized. We've also decided, and this is controversial in some other pilots, that many of our participants, not all, have signed durable powers of attorney, springing durable powers, and healthcare advance directives, which we call healthcare proxies in Massachusetts. The reason for this there's 2 reasons for this. One is most people without disabilities have powers of attorney and healthcare proxies, so why shouldn't the person with a disability have it? Secondly, we are acknowledging that there may be times, we're acknowledging 2 things. There may be times when supported decision-making doesn't work. And secondly, we're acknowledging that there may be times, there are likely to be times, when third parties aren't going to accept our document, even though it's got a notary seal on it. And they're not going to rely on it. Third reason is that families have wanted it. They feel that it's a safeguard, that it's a protection. We've been very honest with people. We've met with them. We said, nobody's tried this in Massachusetts before. We don't have a clue whether this will work. We think it's a great idea. We'd like you to join us in this experiment. We're going to help you make it work, but it may not work. And the backup documents are an assurance for them and for the participants. So we have them sign them. So here's one of our participants. That's Amanda in the middle, and 2 of her supporters. Amanda has a supported decision-making agreement. She decided that the areas that she needs help in are healthcare, legal, finances, home, personal life. She has 4 supporters, 2 in the picture, plus her mother, and a respite worker. another paid person. In perhaps the most interesting case, the one that, to me, brings this the closest to what we want to and hope to achieve, is Corey's case. And Corey is 24 years old. When he has autism and ADHD and probably has some degree of intellectual disability. He gets a lot of services from the state. When he turned 18, and this may be familiar to many of you, and he went to an IEP meeting when he was 17, his teachers and the special education providers and the Department of Developmental Services all said to his parents, you have to get guardianship when he turns 18. So we're going to help you put Corey under guardianship. The parents said, well, we really don't want to do that. We want to be his parents. We don't want to be his guardian. And we want him to grow. But the agencies and the school didn't insist, but they pressured. And the family came to agree to do that. When we approached Corey 5 years later and asked him and his family if they would like to be part of this process for supported decision making, they said yes. So Corey, we went through the process I described earlier. Corey signed a supported decision making agreement. He also signed a durable power of attorney and an advance directive. And I don't know what it's like here, but in Massachusetts, it's a lot harder to get rid of a guardian than to get one. And so you have to to get rid of the guardian, you got to do everything that you had to do to get the guardian, except it's harder. So you got to file all the same forms, you got to have all the medical forms. In Massachusetts, actually, if you have an intellectual disability, you not only have to have a doctor's certificate, you have to have a certificate from a master's level social worker, an MSW, and from a psychologist. So you have to go and get all these, it's called a clinical team. You have to go get this clinical team together, they all got to write reports. Because he was on antipsychotic medication, that's an entirely different system in Massachusetts. So he had to get a psychiatrist to file something saying he could make his own decisions about his antipsychotic medications. It was tough. We also had some resistance from the State Department of Social Services, Developmental Services, Disability Services, DDS. They agreed that he didn't need a guardian, but they didn't think he had the capacity to sign a supported decision-making agreement, a durable power of attorney, or a healthcare proxy because he was under guardianship. That goes to the core of our project. If you can't sign this when you're under guardianship, this is a worthless process for people under guardianship. So we had to fight all of that in court. Ultimately, the probate court judge, we had a hearing, the probate court judge entered an order saying that Corey no longer needed guardianship because he had supported decision-making. That's Corey, that's his parents, and that thing he's holding in the middle is his supported decision-making agreement. You can't quite see the notary seal, but it's on there, I'm assuring you. This is the support people's roles, and we try to keep an eye, we try to make sure we train the supporters, just as guardians get training, we try to train supporters. And this is how many of them used to be guardians, or thought themselves as guardians, or even if they weren't guardians, they were making decisions. And so it's a harder switch than you might think from being the ultimate decision maker to being a supporter. And so we have regular dinners for everybody, and we stand up and do a little talk at dinner to remind them how things work, and that's worked very well. So far, things have worked out pretty well. And we know that the implementation has gone reasonably well. We've gotten about as many people as we suspected as we had hoped for in the first phase. We are now meeting regularly with the supporters and the participants to talk about decisions that they're making and how they're doing it, and that seems to be working pretty well. There has been receptiveness from community members, third parties for the most part. Corey's mom went to everybody that serves his doctor, his dentist, his banker, and showed him the agreement and said, Corey's going to come in and you got to respect the decisions that he said he made. So far they have. Another advantage that we have parenthetically in this project is we're doing it in the western part of Massachusetts is an urban state until you get about 50 miles outside of Boston, where 75% of the people in the state live. And then you're in the western part of the state where there are far fewer people. It's a rural state, rural part of the state. And we're in the most rural of the rural part of the state with almost all of our clients. So one advantage is, Corey, everybody's known Corey in the town he lives in since he was a baby. And so it's a lot easier for us, a lot easier for him to get this agreement respected. We don't know how that would work if he was living in Boston. So we haven't tested that yet. Some of the issues that we're facing and that we want to work with include, what do we do with people, how do we serve people with more severe disabilities? How do we serve people with Alzheimer's, elders who are with dementia? How can in fact this process work for people without supporters? What some of our friends in the elder community call the unbefriended. What about people who are homeless? And we don't know the answers to those yet. That's what we're going to test next. We have an evaluation that's been very, very helpful to us, funded by Open Societies Foundation. And we're going to move on to the harder stuff. We know this can work. We think it's the future of guardianship for lots of people, maybe the majority of people. We think there are real lessons to be learned from this. We're anxious to see how other pilot projects work in the United States. So these are some of the resources. Our website, there's also, which is supporteddecisions.org. There's also a National Resource Center on supported decision making at the Quality Trust in Washington, and that's their website. This is our contact information. Mine, Nanotech Resources. The CEO there is my brother, which is another reason for the nice, friendly relationship with Nanotech. And Elizabeth Pell, who's our evaluator. So we have a few minutes. If anybody has any questions, I'd be happy to try to respond to them. Shirley's got a mic, or will have.
Thank you for your presentation. I have a question. Who monitors the guardian for the party of your supporters, and what happens if they violate the so-called agreement?
Well, that's a good question, and that's something that we have tried very hard to figure out how to do. Because of our relationship with Nanotech Resources, the care managers for Nanotech are we don't call them monitors, but they're the people who are watching it most closely, because they have regular, weekly, sometimes daily contact with the individuals and their supporters. So because all of our participants are supported by a human services agency, the human who we trust, because it's my brother, we rely on them. If we didn't have that, there was a project in New Hampshire about a decade ago that looked very much like this, and they had paid monitors. So they actually had a small nonprofit, and if you entered into one of these agreements, there was someone who worked for the nonprofit who was the monitor, I think they were called. They're thinking in Ontario about having a paid monitor kind of a setup also in Ontario. You really need, your questions are good because you need to watch this. This is, first of all, it's new. Secondly, any arrangement among people, whether it's guardianship or supported decision making or representative pays, it can be abused. And at the core of this, you have a person with a disability. So you really have to, as you create these systems, you have to create safeguards.
Yeah, but what happens? I mean,
Well,
okay, here in Washington, we have provincial guardians isolating seniors and financially supporting them.
Right.
I'm sorry for those of you who don't think that's happening. So what happens if one of these guardians who's a supporter does that to a disabled person?
Well, because they're all in a service system, the supported decision-making agreement can be revoked. We'll know about it, and we will meet with the individual and talk to them about it. Remember, the key to this is that the individual has got to come to these decisions with support, but it's also possible to, the agreement says you can remove a supporter, the supporter can be removed. The remedies are the same to the extent they exist at all that they are for anybody, adult protective services or whatever, if that's necessary. And I understand that adult protective services is not always a good answer to anything, but there it is. You can't build this as a foolproof system. Yes, sir.
A somewhat related question. How does Massachusetts assist in employment?
I'm sorry.
How does
Yeah, that's better. Woo!
how does Massachusetts assist disabled people in finding employment?
Well, Massachusetts is among the states in the United States that's trying to, it's moving a long way toward abolishing sheltered workshops as a place where people with intellectual disabilities at least go for assistance, and moving to supported employment. And the supporters, all of the individuals who are involved in our pilot, with the exception of those who are older, have jobs. Now, those may be half-time jobs, but they are jobs, and they're not sheltered. They're supported employment type jobs.
Thank you for your comments. I think it's been very instructive, and you've given us a good background on the whole issue as well as what's going on in your area. Have you had any thoughts relative to scalability? Where is this headed as far as a potential answer in the larger scale outside of your district community?
Well, that's a really good question, and we have struggled with that. Right now, the size of our pilot is about right for our resources. There is a recently funded pilot in New York. The DD Council in New York has funded a large pilot in New York, but it's large because I think they're going to have over 5 years, they're going to have between 25 and 50 participants. This is not, in my view, this is not something that can be done in huge volume. It works best because of safeguards and because of the intensity of it in smaller projects that can be individualized. There's been some discussion in Massachusetts. We do not have a public guardianship agency or office in Massachusetts. We've had a statute trying to do that for years. The people who are supporting the Public Guardianship Commission are interested in if it's ever created, in having the public guardians also use supported decision-making as an alternative to guardianship. If that happened, that would likely be a big project. But I think there's a scale to this, and I think this is one of the things that smaller is better. We could handle more than we're doing. We're tiny, but I don't think we want to do much more. I mean, we don't want to quadruple.
So I just moved from Texas, and I'm actually in a supported decision-making agreement with the supporter.
Oh, good.
So I had two questions. First, informally, I don't need a formal contract asking people for advice or assistance. And I know all of you, ask other people for market decisions as well. But with the contracts in Massachusetts, because there's no force of law behind them, how does that work differently from a supported decision contract in Texas, where it's part of the law? And then with that in mind, are there federal movements to get more supported decision agreements in law?
Let me answer the second question first as quickly as I can. The association, or the Agency for Community Living, which is a federal agency in the Department of Health and Human Services, is putting a lot of money behind supported decision making. So they have They funded the Quality Trust that I mentioned. They are doing a large research project. So there is federal money going into advancing supported decision-making. The federal government can't tell states what to put into their, well, I guess they can, but it would be unusual for the federal government to tell the states to legislate this. But the commission, this may be a little too geeky for most of you, but there's something called the Uniform Law Commissioners. They're the people who wrote the model guardianship law. They're rewriting the model guardianship law, and it's likely that that model law will include some reference to supported decision-making. That's important because many states follow the lead of the Uniform Commission. On the first question, the biggest difference, I think, between Texas and Massachusetts is at least while you're in Texas, your supported decision-making arrangements recognized by law. In Massachusetts, the ones that we've written, I think that they are legal because this sort of thing, I think, is allowed by our guardianship code, but there's no specific law that makes it, that gives it legitimacy. So we probably need a law.
What can Washington State do to get supported decision-making recognized in Washington State?
Now, I think there's two steps that any state can take. One is to try a pilot somewhere and get some funding for it. A place for funding might include the DD Council or some state government or a foundation that was interested in it. Try what we did. There are a number of states that are doing this: Texas, Maine, Louisiana, North Carolina. There are places where pilots are starting. So that's one way. The other is to think about law reform, to write it and follow the Texas model. It's often a hard sell in Massachusetts that we should do what Texas is doing. And vice versa, for that matter. It's hard to tell the Texans to do what Massachusetts is doing. But Texas got this one. If it didn't get it right there, 99% of the way there. It's really a nice piece of work. Oh, I'm sorry.
In your pilot program, were the overall participants required to have power of attorney and public proxy as signed?
No, we didn't require it. There are several participants who didn't do it. But the majority did it. We made no, other than signing a supported decision-making agreement and putting the notary stamp on it. We didn't require anything of anybody except that they pick supporters and sign that. But we were very careful to explain durable powers and health and advanced directives, and most people chose to do that. More on the healthcare advanced directives than on the durable powers, because most of the participants, the fundamental reason for most people have DPOAs is because of their money, and most of our participants don't have any money. So they're not making big financial decisions. They don't own homes, that sort of stuff. So for some, it was just a healthcare advanced directive. For some, it was both, and for some, it was neither.
My name is Tom Coleman. I'm with the Disability and Guardianship Project, and I'm involved here with everything you've been saying. We're dealing with the easy parts and the difficult parts, and I really appreciate you mentioning the rough areas that need additional attention. My question is whether, do you have any formal training materials or training program for the people who are involved in supported decision-making at all that you could share with others? And then finally, at our booth over there, we have a booklet on supported decision-making and taking a look at some of the difficult areas, so if anyone really wants to stop by our table, we'll be happy to share the materials.
Yeah, thank you for those comments. We don't have any formal training materials, and that's a shortcoming. It's an area that we need to develop. Here's a brief sketch of what we do for training. We spend a lot of time meeting with the individual and their supporters. We spent much more time than we thought we were going to spend. So this turned out to be one of the pieces for us. It was a real learning piece. We've worked with people with disabilities for decades, but we underestimated how much time it would take to prepare people. So there's a lot of training in that. The non-adult care managers spend a lot of time with the supporters, reinforcing their role as supporters and not substitute decision makers. And periodically, twice a year, we bring everybody together and we give them a very, very nice meal at a country club. And we have a speaker. And the speaker doesn't talk for long, but he always talks about values and roles of the supporters. And so we don't want to be, we are trying to find a balance between making sure that people know what and understand the difference between supported and substituted decision making. But we don't want to clobber people with stuff. You know, we want to make this fun. And most people have had a good time with it. They've enjoyed it. They've learned a lot about themselves and their family members or the people they're supporting. And we're trying to make this a very positive experience. We probably should have, materials. And that's one of the next steps that we're looking at over the next year. So I have nothing to share on that other than what I just said. Sorry.
Good morning. My name is Val Olstrom. I'm a member of our attorney, but I'm also a parent. And it's as my position as parent that I started with this and gardening. But my broader question is for you and for colleagues that support this model, which I think is a great one. Is your position that there is no place for anyone for guardianship? And if that's not the case, who would still be in your guardian?
Well, that's a good question. So the pure position, if I were a purist, which I'm not, my position would be there is no one who needs a guardian because everyone has will and preferences, and that will and preferences can be communicated or interpreted by people in a voluntary good relationship. I think as a practical matter, we're not there. We have not, the next phase for us is to try to figure out the next, take it to the, since it's NCAA time, we're going to take it to the next level. We're going to go to the second round on this and try to answer that question: is how, if at all, can this work for someone with a very severe disability, for whom who can't communicate? Can that person's will and preference be known? And frankly, I don't know the answer to that. And I think that's the frontier of this. They're working hard on this in Ontario. We just had a very fascinating meeting with some people from Ontario who are trying to answer this question because they want to get a statute passed in Ontario. And the resistance to the statute is precisely your question. Is this for everybody? And if it's not for everybody, who is it not for? And how do you define that? I had one person say at a meeting, they described something, this may have come out of Bulgaria, I don't remember where, that there was a woman in the hospital who was uncommunicated because she was on all kinds of stuff, all kinds of life support stuff. And the person at the meeting claimed that when they talked to her, they noticed when they were asking her questions that her things on the chart, the tables would change. And they thought that the blood pressure, or whatever it was measuring, the blood pressure or the heartbeat or something, and they thought that with time, that they might be able to interpret her will and preference. They thought she could hear, she just couldn't communicate through watching these things. Now, I don't know. You know, you can buy that or not. that would be a hard sell to a commissioner, I dare say. But it's a possibility. So I don't know the answer to that. I think practically that there is a place for guardianship, that there will always be a place for some guardianship. No country, as far as I know, has totally eliminated guardianship. There was discussion of that in Ireland, and it didn't happen. So I don't think that's going to happen soon. I think the best world is as many people as we possibly can, if we get them under a voluntary system of supported decision making. That's real progress, and if that decreases the number of people who have other people making decisions for them, that's great. And then there are frontiers from there that have to be passed. I want to be honest about this. I hate to come in and give you the sell, but I don't think we're there yet. So thanks for your attention. I think Shirley is lurking. So.
Please join me in thanking Bob again. It was a wonderful presentation. I think Washington has a lot to look forward to as we follow what Texas and Canada and Massachusetts are doing.